what I'm going to talk about today, hopefully briefly. I'm from Trinity College Dublin. It's that nice building in the middle of Dublin if you've ever been there. If you haven't, please come. We will charge you a lot of money to come and see this room, which is the old library. It's very pretty, but you've got lots of pretty libraries in Holland too. But you know, the library needs the money. And one of the things that we have in the library is the Book of Kells. And I'm going to use the Book of Kells, which is an illustrated manuscript of around the 7th, 8th century, to make the claim that Ireland invented copyright in 561 AD, and then nothing happened until our report last year. So you know, everything else doesn't matter. So this is how we invented copyright. So that's the Book of Kells, and Kells is a small town just to the west of Dublin, founded by Saint Columba. And here are two images of Columba, and in the right-hand image, there he is holding a reliquary. And there's a photograph of what he is probably holding in that image. And what it contained was his transcription of a Latin Bible. Unfortunately, he had transcribed the Latin Bible owned by another abbot, called Finian, and Finian was deeply unhappy at the transcription. This is probably one of the 3 pages that are extant of Columba's transcription. So Finian complained to the king. The king is seen here on the right, King Diarmid. And Diarmid said that, and this is a 2 centuries later reproduction of his judgment, so we have a written judgment on copyright from 561, and what it says in the top right in Irish, which I won't bore you with, is "To every cow its calf, to every book its copy," which meant, of course, that Columba had to return the copy to Finian. So a man we revere as a saint was in fact the first known copyright pirate. He didn't like this, so he marched north to his clan, where one of the biggest tribes in the country and one of the most warlike lived, and they started to march south. At the same time, Finian got his guys and the king's guys, and they marched to meet them. And they met there, which is just under Ben Bulbin, which Yeats has written about, at a place called Cuildraine, at what is now historically called the Battle of the Books, and those are books in this representation of the battle, just so as you get the idea. Because Columba's guys were more warlike, they won, but it was a massacre. And because the massacre was terrible, the king banished him, and the Synod of Bishops excommunicated him. So he left and sailed across the sea to Iona in Scotland, founded a monastery. That's the modern version from which the stained glass window I showed you earlier is to be found. And from this monastery, Irish monks went and founded a whole series of monasteries across the continent in the 6th, 7th, and 8th centuries. And an American writer called Cahill says that as a consequence, Ireland saved civilization. So not only did Columba become the first copyright pirate and a war criminal, but he also managed to invent copyright and save civilization along the way. And then nothing happened until this. The Copyright Review Committee 3 years ago. I realise now I'm wearing the same suit. I do have other suits, but it's so you know it's me, okay? Right. We were established in May 2011, and we were given very specific terms of reference, primarily to examine the extent to which copyright could have an impact on innovation. And we took innovation very broadly, not just technological, not just financial, but creativity, ingenuity, renewal and transformation in all of their forms, artistic, cultural, educational and social, as well as economic. That's the last time I'm going to play PowerPoint karaoke. For the rest, you can read yourself. And so we took that as our definition of innovation. We wanted it to be as broad as possible. and as a consequence we said that copyright law should be as technologically neutral as possible and as adaptable as possible. Now the process was exhausting. I should say exhaustive, but I was on the receiving end, so it was exhausting. We had a first public meeting, first round of submissions, and we published a consultation paper. And the consultation paper was entirely submission driven. We responded to the issues that came up during the course of the consultation. We also looked at a range of other reform proposals and developments in other jurisdictions, including the Netherlands. Around the same time as we were established, a minister was saying that copyright needed to be looked at here, and Canada. And I highlight Canada because of what Commissioner Cruz said about a month ago, that the Canadian developments need to be looked at, and in the most recent negotiations between Canada, the most recent trade negotiations between Canada and the European Union, most of the copyright issues came down on the Canadian side rather than the European side. We held a second public meeting on foot of our consultation paper, and at this point we went out shaking the trees. Okay. I'm going to make lots of jokes about trees in a minute, so just hold that thought. Intending to reach as wide an audience as possible. It's easy to get the usual suspects in a room like this. It's much harder to reach individual users. It's much harder to reach people who might have ideas, but they're keyboard warriors hiding in their attics. So our online questionnaire, our online presence, was a deliberate attempt to get a broader view than just the usual suspects. And we published our report in 2013. What's happening now? Well, we had a public meeting to publicise it. The relevant department, the Department of Jobs, Enterprise and Innovation, is in thinking mode, and we may or may not have a new act. I'll tell you more about that in a moment. So, what did we do? We divided the copyright community roughly into 6 different categories. Now, this is a rough division because there will be a lot of overlap between the categories, but we felt that doing it in the following way allowed us to concentrate on some of the issues in a more focused way. We talked about authors, collecting societies. That symbol there is the symbol of the leading Irish collecting society. It's meant to be a cow with a copyright symbol, but it's also got horns, so I'm not entirely sure that they're entirely successful about that. Then intermediaries, poor put upon users and consumers, innovators and entrepreneurs, and heritage and library and so on. So those were the categories we broke it down into. Lots of potential overlap, so this was deliberately a rough, ready, impressionistic and not meant to be constraining series of categories. The European Union, as we know, is thinking very deep thoughts about copyright, and there has been a leak from the Commission giving us a tree. That's not a tree, that's a tree. But I am going to talk a little more about trees in a minute. So, the first thing that we suggested was that there ought to be a broad copyright council. Copyright councils tend to represent one interest in the copyright community, or perhaps 2. But as we started out seeing, we argued that there was a whole range of interests, and it was necessary, we think, to accommodate those interests as much as possible. We recommended that one way to do this was by means of a copyright council, which would be the gardener for the tree. We suggested it should be created by the copyright community as an independent body, independent of all of the various interests and players, with a widely representative board of 14, recognised by the Minister and supported by legislation. And one of the principal objects of the Council was to promote innovation. So for the purposes of today, and for the purposes of our terms of reference, There was a whole range. G was the last, so there's A to F as well, but to promote innovation was one of the aims of the Council. It would provide an alternative dispute resolution service, a location for an orphan works directory, and in general provide education, advice and advocacy relating to copyright issues. In many ways, it is like the similar and subsequent French and Polish digital councils. And if we had seen those developments, we would probably have interpreted our terms of reference a little more flexibly than copyright and suggested that the Council should have a full range of digital interests. And maybe, just maybe, the Minister might nevertheless do so. Are they listening to us on this issue? Probably not, because the implementation of, this is the department's website. It's an ugly, ugly website. Entirely unusable, and it was almost impossible to find our page on the website. I had to keep giving people a direct URL. It was almost impossible to find otherwise. Search didn't work. Anyway, this is their consultation on the Orphan Works Directive, and the implementation doesn't take into account our more general recommendations that included the Orphan Works Directive, which to my mind suggests that they're not listening on the question of the Copyright Council. So, the Copyright Council was meant to provide a generic overview of the various interests, but we made a series of recommendations relating to those interests as well. The first two on the top left of the slide, those are, broadly speaking, rights holders' interests, and if the Commission is to be believed, then the rights holders are the roots of the copyright tree. We did not recommend levies for various reasons, but primarily because we saw them as a private tax on innovation and creativity. The Vitorino report said that it should be done at a national level. The Court of Justice has said that it's a matter for national developments. We therefore felt that we had the space not to recommend levies, and we didn't. But we did recommend specific protections for photographers, and in particular to clarify that copyright can and does cover metadata where it fulfills the criterion of originality, and we provided a definition of metadata and clarified that if metadata is included in a work, not just a copyright image, but in a copyright work, if that's stripped away, then that's an unlawful infringing adaptation. We also suggested to increase the range of remedies, in particular damages, and in particular reaching the profits of infringement, which it wasn't clear from our current legislation was possible. France has just recently done the same, and China is thinking about it and is likely to do the same. So we are international leaders, at least in that respect. As for intermediaries, which are effectively the trunk of the tree, so far as the Commission is concerned, we suggested a clarification of the wording of the exception for temporary copies because of developments in the Court of Justice, but we did not recommend the amendment of the existing immunities or the proposal of additional immunities, in part because of the notice and action procedure process currently before the Commission, and in part because we didn't see a sufficiently strong argument to head in that direction anyway. We also specified that leaking should not be an infringement, and we did that ahead of the Svensson decision, and in a slightly different way, and we consider a better way. But at least we were heading in the right direction. One of the newspapers published an article about our recommendations after our report, but before Svensson, saying that our recommendation relating to linking was a joke that would destroy the newspaper industry. Well, Svensson at least shows that we were right. Okay, now, one of our more controversial recommendations related to something that we decided needed a neutral name, and the name that we came up with was marshalling. And that's because that's what the guys who are waving airplanes in, that's what they do. They're marshalling them. It's a posh word for herding. It effectively covers things like indexing, syndicating, aggregating, or curating online content. A simple and popular example is Google News. This is googlenews.nl from this morning. So just an example of an aggregator. And what we suggested was that a very small snippet of text reasonably adjacent to a link should not constitute an infringement of copyright. So if the link isn't an infringement of copyright, text to give it context shouldn't be an infringement of copyright either. And we defined a very small snippet, less than 160 characters, subject to a cap of 40 words. So a tweet, for example, wouldn't constitute an infringement of copyright. Our inspiration, though not for the detail, was the German provisions, which are now at issue in a court case between the German publishers and Google. And we'll see where that goes, and I think our minister is looking at this before he decides what to do about our recommendations. What did we recommend for users and consumers, whom the Commission thinks are the leaves of the trees? Well, we looked at what we considered to be basic and legitimate user and consumer expectations around things like user-generated content, parody, private copying, and so on. We specifically introduced a recommendation of consumer protection to render void unfair terms that unfairly prejudiced consumer interests. And in that respect, we were heavily influenced by the recent Canadian developments. We also, under the education heading, recommended an exception in respect of content mining. And in terms of the drafting, apart from trying to come up with a definition of metadata, the hardest thing to draft and the thing that changed most between the consultation paper and the report was how we went about accommodating that exception relating to content mining. Eventually, we brought it into line with existing common law fair dealing exceptions. What's happening in respect of our recommendations around consumers? Well, the Marrakesh Treaty in respect of visually impaired, we signed earlier this summer. And the sorts of exceptions that we were recommending in respect of education, the Spanish legislator has just published a draft bill that would do pretty much the same sort of thing. It's not that I'm claiming that we're influencing Spain, it's more that I'm saying that our recommendations here are part of a more general move within the European Union and beyond. The UK has done something similar, but in every respect in which our recommendations and the UK recommendations overlap, ours are simpler. Our intention is to make it easier for consumers and users to take advantage of the exceptions. The UK exceptions, because they're very complicated, are going to be very hard to rely on. We also made some recommendations around heritage, libraries, galleries, archives, and museums. As for innovators, from little acorns, great oaks will grow, and the innovators, if you like, are the acorns that will grow into the oaks of the future. Well, we like to think of ourselves as an entrepreneurial country. We are number 7 on a list in a report published in early summer. The Netherlands come to number 12. Our Taoiseach, our Prime Minister, regularly says that Ireland should be the best small country in the world in which to do business. That's what that hashtag means. So we pride ourselves on supporting innovation and entrepreneurship. And buying into all of the various state reports on that issue, we recommended a special innovation exception for works which are substantially different from the original work or substantially transform the original work. And it goes on to say in a way that the rights owner of the original work wasn't going to do. We were also asked to consider fair use, but we didn't go down the US route. We felt that it was too open-textured, it would frighten the horses. So instead, we recommended the introduction of an Irish version of fair use. And I should say that the orange on the Irish flag is derived from King William of Orange, and therefore there is a Dutch flavour to what we recommended in respect of fair use, not just on the orange of the Irish flag, but also because the Dutch Parliament was talking about it around the same time that we were thinking about it. What we said was that the existing exceptions, or any exception introduced by our recommendations, should be the starting point of any fair use analysis. They should be treated as examples of fair use and should be considered before getting on to the detail of fair use analysis, and should be the basis of argument by analogy. So that, for example, if time shifting is an exception in the legislation, then format shifting by analogy should be recognised. Now, we recommend a specific exception in respect of format shifting, but who's to know what equivalent might develop in the future, and we should be able to accommodate these developments by analogy without having to go back to the legislator every time. And then adopting the American language, we said that it should turn on such matters as the court considers relevant, but we suggested 9 factors rather than the 4 in the US, based on experience in the US, experience in other jurisdictions, and the recommendations that had been made by other law reform bodies and other parliaments. So, the analogy with the existing exceptions, the purpose and character of the use, if it's non-consumptive or if it's transformative, or if it's only a secondary infringement, these will point against a finding of infringement. Relates to the nature of the work, usually the commercial nature, the amount and substantiability of the use, the impact of the use on the normal commercial exploitation of the work, the possibility of obtaining a license, the interests of the owner, and a lot of the language, as you will see, is not just American fair use, but also Berne 3-step, and where appropriate, an acknowledgement of the original source. Now, we argued that we could do this because the right of adaptation has not generally been harmonised at the European level, and this was effectively adaptation. But the leak of the European White Paper suggests, relying on Infopac, that adaptation has in fact been brought within the European acquis, and one of the original discussions of the leak on this issue added the Adam case, which plainly came out after that draft of the leaked report had been completed. On the other hand, there is what common lawyers would say is an alternative stream of authority from Pomuzakai to UPC Vienna, in which the courts have been saying that it's not enough to think in terms of intellectual property, protection and copyright in particular. You should also adopt an interpretation of the Information Society Directive, which allows a fair balance to be struck between applicable fundamental rights, IP on the one hand and freedom of expression on the other. And there is the Court of Human Rights decision in Ashby-Donald, which shows how this might be done. If I can shed any light on the issue, that's my best joke. The key point that I'm making, all right, that's not quite so good, is that there is some space here for creativity. There are lots of arguments that there is no space at all. And the Commission, in its Green Paper, at least in the draft, is saying that there is no space at all. But the last word lies with the Court of Justice, and the Court of Justice tells us that there is some space here. And this is a space in which I think legislators can try to take advantage. And this is why we made our recommendations relating to innovation and fair use, in particular, in the Irish report. And it's a space in which I hope other jurisdictions will follow as well. The Irish response to the public consultation said that they're thinking about legislative reform this year, which means they're still thinking about it. Now, what are they thinking about? Well, some of our things relating to linking and marshalling and so on, they said fine, but other things relating to the Copyright Council, innovation and fair use, they didn't mention at all. So I don't understand why a very small portion of our report was mentioned by the Irish government in the submission to the Commission, unless they're only thinking about a partial implementation, which I think would be a very bad thing. As for the Commission White Paper, well, it's due eventually. Finally, we've just had a new minister appointed. Again, another screenshot from that appalling website, ugly website. Minister does not look good there. He was appointed at the beginning of July, and in a briefing document prepared for him, they said that the examination of the report is ongoing, and it is expected that it will give rise to proposals for legislative reform in due course. Guess what? They're still thinking. Thank you very much.
Thank you very much. Sorry for our lack of sense of humor. But, questions, remarks? Over there.
Yeah, I have a question. To what extent did you review the procedure as negotiated between Eoin and Eoin? So the graduated response, the privatized graduated response in Ireland.
We didn't because we weren't allowed to. There was a parallel consultation process going on in respect of the extent to which injunctions could be obtained against intermediaries, and we were specifically precluded from overlapping with that parallel consultation. We did, however, say that in the context of remedies, given that there were very broad remedies available to rights holders, that there should be some checks. So there were lots of places where we limited. I only talked about places where we expanded damages, but there were lots of places where we limited damages in that kind of context as well. So we weren't allowed to. So I can't tell you what we would have said.
Other questions? Remarks? How frustrated are you? You spend all this time, and now you hear you say, well, they don't take those bits. We're going to see what's going to happen. Are you frustrated?
Yes. I mean, this is a classic journalist leading question. Are you frustrated? And if I say yes, then
why not?
And if I say no, it's a bit sad. Yes, I would like to see some fruits for our endeavours, and in particular where we deliberately tried to push the envelope, where we deliberately tried to reflect the needs of innovators rather and effectively to try and point out that there's a whole range of interests in copyright, not just those of the rights holders. And in the end, if we don't get a substantial part of what we suggested implemented, then I will be very upset indeed.
I'm not only a journalist, but like I say, I'm an author as well. For example, of music. So if say the things you wanted to have seen changed would have gone through, what would have been the most important thing for me as a musician?
Your samples would not be copyright infringing, and therefore will be easier for you to publish your music, publish your videos, and so on. You wouldn't get the copyright problems that you were having as a practicing user, author, creator.
Then I do understand why it didn't go through, but I find it a bloody shame.
Yes.
Another question, yeah?
My name is Susan Riley from the Association of European Research Libraries. We've been doing a lot of work on TDM. I know when I read your report maybe a year ago now. So
Not quite, it was October.
Yeah. But I can't remember what you said about an exception for content mining. What I'm interested in knowing is, do you think we're better off than using that sort of Irish interpretation of fair use rather than asking for specific exceptions for content mining?
Well, what we said about content mining was that it should be fair dealing for educational or research purposes. So we tried to tie that into existing language, so as again not to frighten the horses. And on our approach to fair use, where you default to the existing exceptions first and then come to fair use afterwards, it's always better to have an existing exception. And the extent to which fair use would then develop by analogy, you start with your existing exception. If you're not quite within it, you can then argue fair use by analogy. So the existing exception approach, the common law approach, is the foundation of fair use, again, so as not to frighten the horses. So I think in your circumstances, content mining for research and education purposes would be entirely protected by our recommendation.
Okay, thank you.